I'm just going to see you can button me here and turn on the microphone. Good afternoon, everybody. Welcome back to the free CLEs at the MJC, hosted by the State Law Library. For those of you that don't know me, I'm Liz Ruffy. I'm the State Law Librarian. And with us today, we have Jody Oscarson. Jody is the Impaired Driving Coordinator at the Office of Traffic Safety, which is part of the Minnesota Department of Public Safety. Jody has worked for the state for 42 years. Prior to her current position, she worked in driver evaluation services. So please help me welcome Jody.
Thank you. So today we're going to talk about impaired driving and the consequences, administrative consequences that our department works on. So I'm just going to go over basic knowledge. Probably most of you know it. Implied consent, the per se law. Person stopped or in physical control at 0.08 or higher, they can be arrested for implied consent. We have higher sanctions for those arrested at 0.16 and above. And then at 0.04 for those in a commercial vehicle, they can lose their privileges in their truck. And if they're caught actually at a 0.08, they lose their privileges in a commercial vehicle and their personal vehicle. It also covers controlled substance, Schedule 1 or 2, and it's metabolic, and marijuana. And this is determined by breath, blood, or urine tests, which the officer does, and also refusing to take the test is a crime per statute. And one thing that's important to know that in 2004, this was, legislature decided that these need to stay on record for life. We used to take them off if a person had one violation and they were clear for a while. It was 10 years, then it went to 5 years, and then in 2004, when the laws for CDL changed, then all alcohol offenses stayed on for life. There was a recent change in 2014, I believe, where there are a few convictions that can be expunged, but if it's just the expungement, the implied consent is going to stay on the driving record, unless that's included. So the administrative requirements, these are some of the penalties. They lose their license, their plates get impounded, their vehicle's forfeited, depending on what level that they're stopped at. And new to this whole mix is, in 2011, the legislature passed a law that required a person that wanted to drive legally in the state of Minnesota had to use ignition interlock. For a first-time offender, it's 90 days. For someone with multiple offenses, it can go up to 6 years. And those that are canceled inimical, those with 3 and 10 years or 4 or more on record, are considered canceled inimical to public safety. They have to show abstinence. And we'll get into this individually in the following slides. This is something that's really important to remember because working in driver evaluation, I used to have a lot of people that came in. They'd have a DWI or they'd have something expunged from their record, and or they thought that if they had the implied consent removed from the record and the DWI was on the record, that they'd all get off and it didn't count. Even if you don't get convicted of a DWI, the implied consent is an alcohol offense, and it will stay on the record, and it does count as an alcohol offense for enhancement. And if the person is convicted of a DWI and they have the implied consent, we look at that as one offense. It's not counted as 2 offenses, but it would be counted as 2 offenses if there's an implied consent and they plead down to a careless. So a lot of times people get very upset because their insurance rates go up, and they question us, and they'll go to a clerk of court, and they'll get one story, and then they come to us and we say, no, this is 2 offenses now. And we've talked to insurance companies, and they look at it as 2 offenses. So the only way it's going to be 1 offense is if it's a conviction for DWI and if it's the implied consent. And as I said, this ignition interlock is a big part of our program now. It took over limited licenses and turning letters in to verify abstinence. And I just put this up here because a lot of people don't even know we have this law in the books. I've gone out and done a lot of public speaking. A lot of the public don't know that we have this program. They don't understand it. And so if you can look, the number 2 is a box that's under the dash, and that cord is connected to it, and the person blows into it, and they have to have an alcohol level under 0.02 in order for the car to start. If it's at 0.02 or higher, that car will not start. So then they can do additional tests. And if they can get it started, that's fine. But if they do have a fail, that counts against them, which we'll talk about in sanctions later on. But I just want you to see how that works. Right now we have 5 companies with another one getting certified in the state. And they all have a little bit different machine, but they all work the same way. And if we have any questions, if we can just wait till the end, and then we'll answer those at the end. So a first offender, their revocation period for a first-time offender under 0.16, it's 1 year. And if they plead guilty to, it's 90 days. If they plead guilty to DWI and it's their first offense ever on record, they can have that reduced down to 30 days if we get a conviction for DWI. Otherwise, it's going to stay at 90 days. If their level is a 0.16 or above, it's 1 year, and a test refusal is 1 year. And those for 0.16 and above and the refusal must go on interlock in order to drive legally in the state. Now, currently we have about 10,000 people in our program. We have about 23,000 people that have graduated from the program, but since then, since this law was passed July 1st of 2011, we've had over 130,000 DWIs. So that's another reason I like to talk about interlock, because a lot of people don't know about it and they don't know that they should be driving legally. So unfortunately, we do have a lot of people that are driving illegally in the state, which is scary. First offender under 0.16, they do have an option of a limited license, not driving at all for the 90 days, or getting on interlock. And we do have some people that take advantage of that if they're on-the-road salesmen or they need to drive a long time, because limited is like 10 hours a day, 6 days a week, or 12 hours a day, 5 days a week, and it does limit them. They do have a 15-day waiting period, and they have to have that limit, and they can't be outside of those other hours. Otherwise, they are going to have convictions for violating the limited, which causes more revocations or suspensions. If they do go on that program, they do have to, on the interlock program, they do have to have their last 90 days alcohol-free, or they get extended. A second offense in 10 years, if it's under 0.16, it's 1 year. If it's over 0.16, it's 2 years. And a test refusal, again, is the same as 0.16. And that's because we know they're a higher risk. Research has shown that people that refuse are much higher risk than those that take the test. So their only option is interlock, but they do get full driving privileges. So there's no restrictions. They get the interlock put on their car, they can drive anywhere they need to. There's no restrictions, days, times, or hours. But as I said, they have to have no failed test for the 90 days or they get extended. And they can continue to get extended for every fail they have on that device. The other option is a hard revocation, and which means no driving for that withdrawal period, but we do know that people drive because they have to get their families taken care of, they have to go to work. But we do know that they're doing that, unfortunately. So they need a DWI knowledge test, $680 reinstatement fee, apply for a new license. They have to sign an agreement for the interlock, provide an insurance certificate, and if it's a second offense, they have to do a special review form. And another thing, for the $680 reinstatement fee, there is a law in the books that if they are represented by a public defender, they can provide that proof to the department and pay that in 2 parts. So they pay half now and half in 2 years. But they would need to show that documentation that they were represented by a public defender. And that does help them because the $680 reinstatement fee is one of the highest in the country. Again, the eligibility, 18 years old, must have a vehicle, does not have to be in their name. They can have their parents or their wives or husbands. They can't be suspended or revoked for anything else. And it's only for Class B vehicles, Commercial vehicles at this point are not eligible, and motorcycles, Minnesota made the decision back in 2011 that we did not want this on motorcycles. There are about 4 or 5 states right now that do put it on motorcycles, so I don't know if that'll change in the future because Minnesota has a high amount of motorcycle riders, but right now they're not eligible. So the 3 or more offenses, that's 3 offenses in 10 years or 4 on record. These people are the ones that are canceled and inimical to public safety. The most important thing about this is since July 1st, 2011, if they have an offense on or after that date, they are mandated to do interlock. So my fear is there's a lot of people sitting time out thinking that they can do it like the old way, which the old way before 2011 was they had to go, depending on the time frame, anywhere from 1 to 6 years with no privileges. They came in and they turned in letters verifying abstinence from friends. They did 90 days of AA, and they showed us proof of treatment and aftercare. That doesn't work anymore. So now they do have to do this program. And I've been going out and talking to a lot of judicial districts because I want everybody to be aware and probation to be aware that this is not something somebody can sit out. So they would get a limited license for the first year, and then once they have at least 1 year and they've completed treatment and aftercare, they can go to a full driving privilege. So no restrictions except using this interlock. They do have to submit an assessment telling us what they're required to do, and then show that they've done that. So they're required to do treatment, they have to show they're enrolled in treatment. And then they have that year to complete that. Now, if some treatment centers are going 18 months, 15 months, they have to finish that, so they'd be on that limited for that whole amount of time before they would be able to go to full driving privileges. And they have to demonstrate proof of abstinence with the device. So again, they do the test, the 680, apply for the license, turn in that assessment, and then they have to show proof that they completed the requirements of the assessment, the interlock agreement, insurance certificate, a last use statement, and then they apply for the limited license. So as I stated, anybody that's a first or second time offender that is on this program, the last 90 days have to be alcohol free. So if there's a use, they get extended 90 days. We just recently did an evaluation back in we finished it last fall. We had a gentleman that went on in 2011, first time offender, had the interlock, and he actually was extended 4 years because he continually failed on that device. The reason we have this provision is because when this legislation was going through, our office was kind of assigned to do the research, and we found that in Washington State, they had a program where they put people on, they didn't monitor, they just put the people on and said, here, and drove. And they had a gentleman who, after 6 months, got off the program, within a month, killed a child. When they went back and looked at his reports, they found that he was using every day. So they actually changed their laws that the person has to have 120 days of abstinence with no fails on the device, or they get extended. So we decided we wanted to do that because what we're trying to do is change behavior, change people's attitude about alcohol and drinking. And so we don't want people to just do a program, and we don't want people to just be put on a device and make it look like we're doing something. We want to monitor, we want to try and change that behavior, and that's part of it. For those that are canceled and inimical, if they have a .02 or higher reading, they get canceled out of the program and they have to re-enroll. I was just talking to driver services, and we actually have a gentleman who right now is extended to 2064 because he has failed so many times, and he's already had so many offenses. He keeps failing on the device, so they keep adding time on. There is some legislation that Mothers Against Drunk Driving that's going to, I think, bring forward this year. We've tried it in the past through the DWI task force to change this so that there's less less time that they're extended, because what happens is the person gives up and they'll just go back to driving illegally. We want to change behavior, but we don't want to punish them to the point where they just give up and start driving illegally. We want to keep them on the device because it has shown that it does save lives. In fact, with our evaluation, it showed that we saved lives and they were actually safer drivers. They had less violations and less crashes than other people. And we're not sure why, but comparing it to a group of people that didn't go into the program, they were safer drivers and the recidivism was much lower than those that didn't go in. So these are non-alcohol violations. These are what can get them extended besides alcohol. If they tamper, circumvent, bypass, if they drive a vehicle that's not equipped with an interlock, they have a restriction on their license that states must drive a vehicle with interlock. If they go and they use another car and they get caught, they can be ticketed for that and they'll receive an extension. If they violate their limited license, that's also an extension. If they skip the 3 rolling retests in a 7-day period, that's an extension. And for those that are canceled and inimical, the way that earlier I said that they had to verify their abstinence instead of those 5 letters, which usually was their AA friends that filled out the letters, they now have to do 30 blows per month. And this isn't perfect, and we keep trying to figure out a better way to do this because, unfortunately, it's not required to do a blow into the device once a day, every day of the month. They can do 30 days in 1 day, and we'll accept that. We have to just figure out how to work it with a large population. And then if they miss a calibration visit, when they're on this program, if they have a wireless device, they have to go in every 60 days, get it calibrated to make sure that it stays accurate. If they have a device that's not wireless, then they have to go in every 30 days. And if they miss that, the company will shut down the device so they can't start, but they do get extended if we find out about that. And these are the sanctions. At the time of the legislation, it was decided to do the sanctions the same as our driving afters. So it was 180 days, an additional 1 year, and an additional 545 days. So you can see how that can add up in addition to the alcohol fails. This is also something that Mothers Against Drunk Driving is looking at trying to get changed. Instead of adding it on to the end of the time, doing it at the time of the offense so that the person is aware of it, and it kind of is also a point of trying to change that behavior and lessening the amount of time. Because again, we don't want to discourage people from using it. We just want to try and change their behavior by having some kind of sanction. So the people that are canceled and inimical, we've had a restriction. It's called a B card restriction. A lot of people refer to it that way because a long time ago, we used to have 2 cards. You'd have a driver's license and you had an additional card. And that had all your restrictions. And it was also always referred to as a B card. And that's kind of stuck with this restriction. And this restriction is any use of alcohol invalidates a driver's license if you're caught drinking anywhere, anytime, or using drugs. So it doesn't have to be just in your car. It can be if there's a domestic and the police get a valid test, PBT or some other test, or probation officer, they send that into the department, they get canceled again, and they start their time over. But that restriction is on the driver's license. It used to be a lifetime restriction. So you could have gotten that restriction at age 20 and had it till you died. Back when we did this legislation in 2011, the legislature decided that that was too punitive, and they felt that people could change. And so once the person completes 10 years of abstinence and they can prove to the department that they've done that, they can have that restriction removed. But if they do get another violation, it will go back on the record. And then we have the criminal vehicular operation. And this is where somebody has harmed someone or killed someone. And that causes a revocation also. This is, I think, the worst of the worst. But what I want to talk about is that in the past, people that had this would be ticketed, but they would not lose their license for a long time. In 2014, that law changed. And now if the officer suspects that there was alcohol involved, they can send in a notice to the department and the person gets suspended until we get the conviction. And part of the motivation for that was the fact that you had people that had a DWI, first-time DWI, 0.10, they lost their license within 7 days because that's how the law set up. You had someone that committed a terrible crime, hurt somebody because of their drinking, severely injured someone. They kept their license until they went to court and we got the conviction. And what I was seeing in driver evaluation is some of these people went 2, 3, 4 years with a valid license. And victims' families would come in and say, why is this happening? Why are they still driving legally? And it was a good question. It didn't seem fair. So this was changed so that the law enforcement can send it in, they're suspended and they're required to go into the interlock program. They stay on that till the conviction comes in, and then they'll get credit for the time served. But at least there's some type of a sanction for someone that has harmed someone. Now, the only thing that the legislature has not been able to do is do this for people that have killed someone. There's something that fatalities, giving them an interlock for somebody that's been killed is favorable. And I think those are the people that need to be monitored the most. They've killed someone because of their drinking, and they should have this on. And a lot of your advocate groups, Mothers Against Drunk Driving, Minnesotans for Safe Driving, all want to have everyone to have interlock, no matter what the situation is. So that's something else that will be coming up in the legislature, I believe, this year or next. And then just in case anybody has a problem with what they've been charged with, we have a judicial administrative review. So the administrative review is conducted by our department. They just fill out a form, send it into our evaluation program, our office. That's reviewed by a driver evaluator and determined after they look at what the person has stated and what the police report states, if they should stay revoked. And then we have the judicial review, which is conducted in court. And that's basically taking our commissioner's office to court. The AG's office fights that. And that can be removed if they're found that there was a problem with the arrest. Otherwise, it will eventually go on record. Right now, it'll go off the record until it's decided. So they're basically not found guilty in the meantime. So it'll go off the record, and then once we get the information back from the AG's office, it will go back on the record if the person is lost. From 2007, I think, till 2013, we had a lot of offenses removed because of our breath testing machines, and that was over 4,000 cases. Those are back on the record now because they lost eventually. But what was interesting is in the meantime, when those were being handled, we had a lot of people getting second and third DWIs. So it was an interesting time trying to figure that out when we got all those back. But just a little side note. Any questions? Yes?
How does all of this relate to whiskey plates?
Whiskey plates are plates that are issued in circumstances such as when there's child endangerment or second offenses, multiple offenses, you get a whiskey plate, or if it's 0.1, first time offender, 0.16, you can be issued a whiskey plate. If nobody knows what that is, it's a plate that's put on any car that you own. So if I was stopped for a DWI of 0.16 or above, any car that had my name on it would have a whiskey plate put on it. And right now the law states 1 year until they're reinstated. And you'll see those because a lot of them start with a W, and it's just 2 letters and then 4 numbers after that. And anytime I tell people that, they come back about a week later and they say, I can't believe how many of those are on the street. Because you can see them on your way home. You'll notice it. But that is part of that plate impoundment piece, is that they get those plates.
And they're black and white, right?
Yes.
Yeah. They look like the Minnesota State official plates.
Yeah. Yeah, every once in a while I think that's a whiskey plate, but it's actually a state vehicle. Because when I see them now, I look for an interlock. I'm thinking, well, they should be on interlock. Most of them should be on interlock, but it can be a family member too, so. Yes.
I can see practical scenarios where the interlock device gets damaged by your kid in the car, or something happens, somebody borrows your car without trying to disconnect it.
Yeah.
Is that part of the administrative process too?
That's part of the administrative process, and they should contact the department immediately. Yeah, because there are going to be circumstances, and that's the other thing people have to understand is when this person signs up for the interlock program, they are responsible for anybody that drives that car that has, if they have alcohol. The device does have a camera, so they may get a cancellation notice because we're not going to be able to look at every picture. So say my sister uses my car and I have the interlock, but she was blowing a .04 on it. I could get the cancellation notice, but what they would do is either call in, file administrative review, but they can also come in and see an evaluator. The evaluator can look at the pictures, and if it is someone different, they can remove that from the record. They can stop that incident. But the people have to understand that they are responsible for those fails on the device. So when they have someone using that device or that car, they need to make sure the person understands the rules. And they can't rent a car. That's not part of it. They're not allowed to rent a car because right now that's not feasible. Rental cars don't have interlocks. All 50 states have some form of an interlock law. Some very good, some just let the device be put in the car for 6 months and don't do anything with it. They are trying to change their laws, but it is hard to do. But all 50 states have it. Eventually, I foresee that rental companies may have a car or two available that have an interlock. But technically, they shouldn't be renting a car to anyone that has that restriction.
It's a question from the webinar participant. How do convicted defendants learn about all of these rules? Is there a meeting after sentencing conviction?
Our office started about a little over a year and a half ago, going to transition fairs. Myself and another person actually go into prisons now that ask for us to come and talk. We go in and meet with prisoners individually that are getting out of prison to talk to them about their records. What we ask is the probation person that's in charge, get the person to sign a document that allows us to pull a driving record. We get their information, we pull all the driving records, and then we go out to the prison. We just recently went up to Moose Lake, met with 30 different individuals that were getting out within the next 6 months, gave them all the forms they needed, give them the information that they have to have. That includes if they have unpaid fines, if they need an insurance certificate, whatever they need to do. We've been doing that for a little over a year and a half now. And so it's catching on with the different prisons. We've been to Stillwater, Lino Lakes, and 2 others, I can't remember. But we've been doing that, and we're also, in the next 3 months, going to 2 or 3 transition fairs. So we are trying to get that information out because we've talked to all the probation officers. I've met with a lot of judicial districts, and I think now getting down to that group, and a lot of them may not be just in for DWIs, but that is part of their record. And so ultimate goal of our office is to get people driving legally, because when they're driving legally, they're driving insured, which means that's better for all of us on the road that are doing things correctly, because if they're not insured, it comes back to us. My daughter-in-law was hit by somebody a year and a half ago, and she still has not seen any money from it as far as recouping that. It all came out of her insurance, and she had to pay over $4,000, and they kept saying that she'd get it back. But these people don't think about that. If they're driving illegally, they most likely are not insured. And so our goal at our office is to make sure, that's kind of my mantra, get them insured, get them licensed legally, get them insured, so all of us are protected. Any other questions? Yes, sorry.
How is a vehicle forfeited and who gets it?
Well, the vehicle is forfeited by law enforcement, depending on what the situation is. when they're stopped. And, that kind of depends on the law enforcement agency. Some of them don't forfeit it because it costs so much to forfeit the vehicle. I know our state patrol forfeits vehicles, and it's very costly to keep those vehicles because a lot of them are not nice vehicles. But there's some good example, I believe it's Savage. They forfeit vehicles. They're taking those profits from selling the vehicles, and they are actually now helping those that can't afford treatment. They're using that money to help these people get through treatment. And it's been controversial at the legislature. Every year the legislature has tried to do something with forfeiture to get rid of it. So far it has stayed as it is, but it depends on the law enforcement agency, what they are going to do, and if it's too costly for them. Because you have a storage issue and all of that, so. Yes?
Does your office have an estimate of how many people are driving illegally in Minnesota?
Well, as I said, since 2011, we've had over 130,000 DWIs. Typically, now last year we had about 24,000 DWIs, and it seemed, to the public, it probably looked like they went down, but they really didn't, because at the time, we weren't able to count those that had to go through a search warrant process, because the decision that was done by the Supreme Court, that changed this year, July 1st, that changes, now we can start counting those. But anyways, we've only had 20,000 people go through this program that have graduated. We've got about 10,000, we always state about 10,000 that are currently enrolled. Your first-time offenders under .16, about half of those people don't reoffend, and they get their license back very fast, like within the 30 days if they plead guilty. So I think my estimate is that we've got about 40,000 people that should be in this program that are driving illegally right now, just since 2011. But we also, before that, we had a high amount of people that weren't getting relicensed because the reinstatement fee, the cost of insurance, and that's part of the problem with the interlock program is people can't afford the reinstatement fee, $680. They can't afford the insurance because they have to go tell their insurance company that I have a DWI because they need to get an insurance certificate. They're not just showing proof of insurance. Their rates go up. We also deal with a lot of DWI courts, and what the probation officers tell us is their rates go up to $1,800. They give up. They don't do it. They would rather risk. It's cheaper to drive illegally because your driving after ticket is about $200. So you get caught 3 times and still not pay the same as a reinstatement fee. So unless you're in a small town and the officers know that you're driving illegally, it's pretty easy to do it. Unless you're not driving, you don't drive well, but. I mean, look at the woman that hit the officer. She wasn't a valid driver and hadn't been. She had a lot of violations on her record. And that's why I say our goal is to get these people reinstated and get them insured. Did that answer?
How are you going to do that? It's a lot cheaper not to go through the process. You make it more expensive to get caught.
Well, we've had a couple talks with the courts about not making it payable. And there was some legislation a couple years ago to try and figure out a way to, at least if they had a second driving after, they had to go to court. When I was back in driver evaluation many years ago, they used to have to go to court, and they'd come in and say, I have 30 days to get reinstated, because the judge wants to make sure I'm reinstated. And they would come in weekly, because this group of people, it's hard for them to follow. So they'd come in with a list every week and say, okay, I took my written test, now what? Okay, go pay your reinstatement fee and apply for a license. And they would do that so that when they went back to court in 30 days, they had everything done. And then they wouldn't get convicted or it was being stayed. Now with the payable, it's pretty easy. They just pay that, or they don't pay it. And they can continue driving. So it is hard, but that's why I try to work with probation so that they can kind of direct people into this program and help them. Explain to them that for fines, they can talk to their county office and see if they can get on a fine agreement. Because if they get on a fine agreement, they can get reinstated if that's the only problem they have, as long as they keep paying on that. So there's a lot of nuances to the law that the people don't realize, and I think they hear everything that they have to do and they just give up and figure I can drive illegally. So that's why we started going out to the prisons to try and reach these people, and we go to the judicial districts and talk to probation officers, judges. I just recently talked to some judges in Anoka that didn't realize that somebody was mandated to do interlock, and they didn't know that there's a 2-part fee that the person could pay, which would help them get into the program. So a lot of it's just educating people that can help them get through the system.
I have a question from the chat. How much does interlock cost? What financial assistance options are available for indigent persons required to be on interlock?
A typical interlock, it's anywhere from $100 to $150 depending on the car to get it installed. It can run anywhere from $75 to $130 a month depending on what company they go to, which they're free to go to any company. All companies have basically the same device and the cameras and the reporting requirements. They're all certified by the state. We do have an indigent program that if they are determined to be indigent by the department, they only have to pay $40 a month. That's, the manufacturers have been told that's if they're given a letter that they qualify, they bring it to the manufacturer and the manufacturer will only charge them $40, $25 to install, $25 to remove it, and then a couple fees for if they get locked out or anything like that. But all the fees are reduced for people at that. I've also got, like I stated earlier, I have a grant program where I've got 8 judicial districts right now where I help offenders. I give money to those districts. The agreement is if it's part of the court order or if the person is requirement of probation that they're in the interlock program, we subsidize part of their fees for a year so that they can get into the program, learn how to make that part of their monthly payment, and at the end of the year then they've invested a year and they've got, they learn how to drive legally and they're not looking behind them for the cop car. But that's been very successful in those. I just signed up Dakota County and Anoka County for that program. So they'll be doing that too. Any others? Yes?
Person has their license revoked and say they blow at 0.2 and so there's license automatically revoked right when they give their breath test, as I understand it, for a year. Is that right?
Depends on how many they have. So if it's a first offense and they're 0.20, that's above the 0.16, so they're revoked for a year, but it does take 7 days before they're revoked.
Okay, let's say that they either their court case is dragging on or maybe the prosecutor is deciding whether to charge them or not and their court case isn't resolved. Is there a way for them to get their license, some sort of license, without having their court case resolved?
They don't need a court case resolved.
Okay.
Because it's administrative, so for that scenario, they would be revoked for a year. They could get into the interlock program, because that's the only way they can legally drive. And at the end of the year, even if there's not a conviction, we're still going to reinstate them, because they've done their year revocation. So that conviction doesn't matter. The only time the conviction matters is for the CVO, for those that aren't fatalities, because they're suspended right now, and then they stay suspended until we get the conviction.
But if you use the interlock system, you can reduce the year suspension, and you can, no?
No, there is no reduction in time.
Oh, so you can't start using interlock until after a year?
No, I'm sorry. They can get on the interlock right away, and they can use it that whole year.
And can they get on interlock without their criminal case?
Yep.
Oh.
Yep. I'm sorry, there's some states that if you go into the interlock program and you have no fails for so much time, they'll actually take time off of that. I think it's a good program, but we have to get laws passed to do that because it's encouraging people and it's helping change behavior. Research has shown that type of a program actually does change people's behavior because they're getting a reward. So that's what I meant when I said that, so I'm sorry. There's one other thing that there's a lot of miscommunication. If someone goes into court, so they've been stopped at the .20, They go into court and they plead it down to a lesser under 0.16. There's a lot of belief out there that we're going to reduce that time down to the 90 days. That doesn't happen. If it goes on the record as a 0.20, it stays that way. So it's going to stay at the year. That has come up quite a bit over the years because they've been told by their lawyer or somebody at the court that, oh yeah, if you plead it down, you're going to get lesser time on your license, and that's not true. Yes?
Does the date start from the date of the offense, the 1 year?
No, because, so if they got stopped today, they'd have 7 days to take care of all their things. So then 7 days, then the revocation starts. But they have valid privileges during that 7 days. When they're stopped, they're given a document that shows that they can drive until a certain date and time. Because we have a system, it's called e-charging, and so it prints out a temporary license and it tells them the exact time and date that they cannot drive anymore. Any other questions? Yes.
Oh, go ahead. I have another one from here. There have been cases where individuals have successfully challenged the reliability of the ignition interlock device in implied consent hearings. Is DPS taking action to acquire more reliable devices?
They are always looking at, so the devices that are out there are certified by the state, and those certifications are requiring that those devices are tested through certified labs in the country, which is following NHTSA guidelines. So they are good devices. I'm not sure, I'd have to know what the basis is for it, but they are certified. They all have to go through a process of a lab. We've had, a few years ago, we had a situation where a manufacturer was in, and we found out they weren't doing what they were supposed to be doing, and they got decertified and removed from them. They had to leave the state, basically. One of the things our office did shortly after this law became effective, we hired a person, a retired police chief, to create a vendor oversight program. And he's done a phenomenal job. He's actually been recognized nationwide for our program. And he now goes out and he can train other states on how to have an effective program. But his job was to create a program to go out and check the difference. We have 170 different substations that these manufacturers have where the person goes in and gets calibrated. So he would go in and make sure that they're doing what they're supposed to be doing, that they're following data privacy laws. If the person was doing something wrong, they worked it out with the manufacturer to make sure that they didn't do that or that person was shut down. And so I think the department has tried very hard to make sure that these are reliable devices. We're always going to have that situation where something happens. But like I say, I would need to know what the situation was.
Yeah. There is one more question. What prevents someone from having someone else start their device?
Well, there is a camera in it, and we've seen that happen because, there is a subset of group that, as long as I've been with the department, they work harder to try and circumvent the law than just following the requirements. We have seen that. And we do have a couple manufacturers that will, if they see something that in the reporting that doesn't seem right, they'll go and look at those pictures, or they'll send the pictures to us, or we'll look at the pictures. So it can happen if they know how to do it. But a lot of those have a breath pattern, so you have to blow, suck to start the device, or you have to hum and blow. So it's not just like in the old days. We had a program here in 2001. It was run through Anoka County. We had 9 participants. The device didn't work because of the cold. And people were able to use balloons and air pressure tanks and that type of thing to start it. We didn't have that. These companies actually do work very hard to make sure that it's a person blowing into the device. The cameras have gotten much better at being able to see. We do have people that circumvent, but we also have people that are driving illegally. Like I say, it's not perfect, but I know for a fact that it has saved lives in Minnesota.
So another question came in during that one. What happens to a person who does not get a new license after the 1-year interlock restriction has been lifted? Can that person still be cited for not complying with restrictions?
Well, if they're not meeting the requirements, they could be cited for driving after. So even after the year, you still have to meet your requirements. We have people that have been canceled and denied for 20 years, and they've just chosen not to do what they have to do. So if they're caught driving, they're going to be cited for driving after. Yes?
I was curious about how prevalent these interlock stations are. I mean, are there some people that have to drive like 50 miles to get one?
Every manufacturer is required to have a station within 50 miles of a participant in the state of Minnesota. There is a little leeway up in that corner of Minnesota where there's really nobody. I think some people have to drive a little farther, but they also have the ability, there's a couple of manufacturers that do have mobile. So it's not perfect that they go and they get it installed, but they can get it calibrated that way. So they could get it installed at the station and then have it calibrated. So that is a possibility. Yes?
Can you comment at all on the statistics of other methods of impairment other than alcohol in the state of Minnesota? Revocations, suspensions for persons who are found impaired on prescription medications or other types of substances?
Well, I can tell you that they are still, if they're revoked under the alcohol 169 chapter for alcohol, drugs, they still have to go through the interlock program. Right now, there is no other way to separate that. When that law was passed, it was all under that statute. And I know there's a lot of people that don't agree with that, and we need to find a way to figure that out. I know there was some legislation 2 years ago that was going through the legislature to separate out those people from drugs. But what people don't realize is one of the reasons we did this in 2011 is a large amount of these people use alcohol and drugs. And if they don't have access to drugs, they're going to go to alcohol. They're going to use some substance. So they still are required to go through the interlock program at this point. As far as prescription drugs, no, I'm not going to get into that. Yes?
Can the interlock detect drugs alone?
No. But when I've talked to probation officers that see a drug offense, they step up their testing on their side. So I know there was, when this program first started and we were going out and talking to different groups, we had a lot of law enforcement that were upset because they said, well, I'm stopping people that are high, they're not using. But unfortunately, that's how the law was written, and nobody's come up with that perfect way to handle it. And I know with the drugs, as they're becoming more prevalent in Minnesota, it is an issue. We even looked at one point of requiring that they wear a patch, and it's like, well, that's not going to work. Who's going to monitor that? Because we don't monitor that type of behavior. So when I met with probation officers from around the state, they said, well, when we see that, we must step up our monitoring to make sure that they're not using drugs, and if they do, we sanction them. And part of this is years ago, when I first started with driver evaluation, many moons ago, the thought was we have to punish because we don't think the courts are punishing enough. And when we did this legislation, it's like we have to trust the courts are doing what they're supposed to be doing. We did trust that probation is doing what they're supposed to do. Our job is to administratively revoke their privileges and deal with it that way. My hope and dream is that someday there will be a device that will do that. I do know that there's 2 manufacturers that are trying to figure out how to have a device that can detect drugs. The problem is how to narrow that down, because there's so many things and they keep creating new drugs. I mean, you get something that you can figure out and then these people can change just one thing in the makeup and now we have something else out there. So, but I do know that there's a couple manufacturers looking at that because they do know that's a common complaint across the country because so many states have gone to this interlock for people with DWIs, so. Any other questions? None? All right, well, thank you. I hope it helped.
Thank you.